Hi, everyone. This is the time of year when many organizations in the capital community are lobbying the governor's office, hoping to get him to sign or veto one bill or another. The CRA isn't the only business association feeling a growing sense of dread about the economy. The frustration comes from the fact that elected leaders have done little to directly address the economic crisis. There are 3 bills that Governor Newsom has signed into law so far that impact employers. SB 1383 mandates additional paid leave for employees. AB 685 requires public notice of COVID-19 exposure in the workplace. SB 1159 is an expansion of workers' compensation. Let's talk about workers' comp today. That bill took effect immediately upon the governor's signature last Thursday. It makes employees who have the coronavirus eligible for workers' compensation benefits. You may remember back in May, the governor signed an executive order establishing a rebuttable presumption that all employees required to work outside the home infected with COVID-19 contracted the virus on the job. That was quite a presumption, since a person could get the virus at any number of non-work locations. That executive order expired on July 5th, and then the legislature was faced with workers' comp proposals that were even more unfair to employers. They would have imposed broad new liability on struggling restaurants to pay for COVID-19 cases that were unrelated to work. Thankfully, lawmakers rejected those in favor of SB 1159. SB 1159 picks up where the executive order left off, meaning it is retroactive to July 6th, but it applies only if a workplace experiences an outbreak. For employers with 5 to 100 employees, an outbreak is defined as 4 or more infected workers who work at the same location within a 2-week period. For employers with more than 100 employees, outbreaks are defined as at least 4% of workers working in the same location being infected during a 2-week period. So if there's an outbreak at work, workers don't have to prove they were infected on the job to get benefits because the law assumes they got it while working. The burden of proof is on employers who want to deny workers' comp coverage. They have to prove that their workers did not get the virus while on the job. These mandates, despite their good intentions, come at great financial cost to small businesses at a time when restaurants are fighting for mere survival. The other 2 bills I talked about a minute ago are also important. CRA members, we've sent information to your inbox about all these bills, and you'll continue to receive more communications from us through September 30th, which is the governor's deadline for signing bills into law. The CRA is still calling on the legislature and the governor to return to Sacramento for a special legislative session to address the CRA recovery plan. That plan includes protection from unwarranted lawsuits, relief for restaurants being evicted, tax credits or offsets for the increased minimum wage, and for the costs associated with false reopening, a pathway for forgiveness of government-imposed fees, and a hiring tax credit to encourage hiring in all restaurants. I'm Sabrina, and I'll see you back here next week.